What is judiciary's view on the certain sections of Citizenship Act?
Yes, sir. I would say that citizenship has been in the news since the Citizenship Amendment Act of 2019. It has been an act which has created a lot of stir in the public, and there has been protests against certain sections of the Citizenship Amendment Act of 2019, and it continues to be under scrutiny. And we are waiting the Supreme Court's analysis on that particular aspect of the Citizenship Amendment Act of 2019. But recently, what we have seen is that judiciary has taken a very liberal way in which they have interpreted Section 6A of the Citizenship Act. And Section 6A primarily relates to the Assam Accord. And Assam Accord has provided a certain kind of a relaxation to the people who entered Assam from 1966 to 1975. And what we have is the 1st January 1966 to 24th March 1975. And we have a kind of a, we have provided a new mechanism through which we wanted the people to be provided the citizenship who have entered during this time. So we recognize them as foreigners, but we allowed them the opportunity to be a part of the India by taking up the citizenship. And this aspect of Section 6A was under a lot of sections of the society. They were not very happy with respect to the fact that categorization has been made in this particular Section 6A. So one categorization is that if you have entered India before 1966, you will be considered as an Indian citizen. But after 66 to 75, the situation was very different, whereby you were given an opportunity. And after 75, what you had was that you were treated as illegal immigrants. So this categorization has been a big point of contention, and it was believed that this is something which may violate Article 14, the reasonable restriction aspect, which exists under 14. But the government has been saying that Article 14 also allows for a certain kind of intelligible differentia. And if there is a rational nexus to the objective of the legislation, then a reasonable classification can be done. And the government has continuously been saying that this classification is quite reasonable under Article 14. So very recently, in a major verdict, the Supreme Court has come out and they have agreed with the government's viewpoint, and they have allowed the government that these differentiations, categorizations which were made under the Citizenship Act, they are well within their rights to do so. And this has been looked as a positive development from the perspective of the All Assam Student Union, who was the major proponent when it comes to the entire agitation which happened from 79 to 85. And now they are quite happy, and they're saying that the judgment reaffirms the commitment to the Assam Accord, which the Rajiv Gandhi government signed with them. And so judiciary's outlook of allowing the government to create this kind of a distinction under Article 14 with respect to Sections 6A, this has been considered to be a liberal viewpoint, whereby the government has been able to uphold the Assam Accord. But now the question comes that the same kind of categorization the government has also done under Citizenship Amendment Act of 2019. So now, to what extent will that be upheld or not? That remains to be seen. And that is somewhere where we'll say whether the judiciary upholds that kind of a reasonable classification, or that kind of a reasonable classification goes against the basic structure, which is the secularism to the Indian Constitution. So that is something which we really have to keep in mind, and we really have to follow, and we have to see it that when it comes, it becomes a very important aspect, not only from the examination perspective, but also from the perspective of the larger social fabric of the country, I would say.